Without any further ado, welcome this morning. I'm Beverly Carter. We're doing an exploration of life called the Death Series. And today we're just talking about, the documents that we have in place that we all know, a will. We're talking about what shade of gray is your will. So is your will up to date? And that's kind of an important deal in my world. And a lot of people don't realize what they need to know. I'm a notary. I've been commissioned for just over 7 years, and I have 3 PhDs in life. And that allows me to talk very pragmatically and honestly with many, many people. So just coming up, a couple of days ago, we had insights from a medium. That was a great session. Today, what shade of gray is your will? And then upcoming in a couple of weeks, we have discussions with a death doula. We have Dr. Linda Franchi. Fascinating to learn about what a death doula is. I think many of us are more familiar with the concept of birth doula. So I'm really looking forward to getting some insight into what this role is and introducing people to some new options. Then we'll be talking with Dr. Nina Belmonte about the philosophy of death, and we're really looking at the evolution of how we look at death, the historical aspects of our Judeo-Christian culture. So stay tuned for that. And then we have Meet the Mortician, which is a more pragmatic look at, kind of end-of-life planning and dealing with our bodies. So trying to take away the mystery of some of these aspects of death and dying. Today's topic, what shade of gray is your will? We'll be covering how often you should be updating your will, assessing whether or not your will is actually up to date. We'll be talking about getting over the stumbling blocks. Are there any obstacles? What's stopping you from starting? And then any other things that you need to consider in getting this very important document up to date. So what shade of gray is your will? So you'll see, I'm just gonna leap up a bit, I'm wearing black and white. And so I've used the concept of black being, you have all of your written text on a white paper, and that means you have an up-to-date will. If it's all white, it's blank. So you're in the black when you have a current will and it's up to date. You have the right person for an executor. You have the right person for guardian of your children, if that applies. You have the right beneficiaries. You have them in the right order, and you have the right amount of inheritance or money being gifted. You're in the white when nothing is done, nada. Blank sheet, never started, not planning on one. And we'll talk about some of this, some of the reasons that people don't have one in place. And I'm just going to give the quick caveat that there are some people where not having a will may actually be the right option for them. It is very few, but it's not something I would leave to chance. It's something that I would get legal advice about, but there are some situations that warrant not having a will. But I'm going to say for 99% of the people, you should have a will. So black, white, everything in between. Your will may be simple or straightforward, but your life isn't always. And it's really, that's the part that creates a huge gray area. And it's a very common daily conversation I have with my clients. Quick question. Don't know if I know the answer to this, but is gray spelled with an EY or an AY? Just asking, came to my mind. So just thought I'd lighten this a little bit with that particular question. If you know the answer, stick it into the chat. Let me know. So common reasons, I think starting to look at your will, whether or not it's updated, is starting to look at common reasons people may avoid making a will to start with. And I hear these frequently. So a lot of people will say, I don't have anything. And actually everybody has something. Everybody has a bank account, at least, and everybody needs an income tax filing. So that's not the only reason, but it helps guide people if you have something in place, but it's not a good reason to not have a will. Some people will consider money or cost concerns. They see that the will is like a discretional spending. They may spend $200 on something online, but they're not going to spend, $300 or $400 on getting a will done. Some people feel they're tempting fate and they can't or won't face their own mortality. Oh, the family already knows what I want to happen. They'll deal with everything. I've heard that twice this week already. I'm still thinking about what to put in the will. I'll do it when I need to. Just general procrastination or putting it off till later, very common. Family structure. There may be estrangements, complicated dynamics. They don't want to upset somebody, and they don't want to choose. That can be part of a procrastination as well. Some people are private. They don't want to discuss any personal matters with anyone. And some people don't care. So some of the obstacles, I'm going to say that those are a lot of reasons, but I think in talking to a lot of people, and I'm going to say particularly, I'm talking with the kids of a lot of parents, I find that a lot of them just don't know who to trust. They may have the perception that lawyers are really expensive. They may not know that notaries do this, or they just don't have somebody that they've ever met that they trust. They don't know where to turn. There's also the notion of not knowing how to organize themselves, and that's actually quite common. Just where do I get started? And I have some strategies around that I'll bring up later. And some people have just questions that they need to, they're mulling over things, but they just need one or two questions answered before they can sort of make their decisions and then get on with getting the will. And that sort of ties into who to approach. So we'll talk more about that. So overcoming these obstacles are, you could set up a consult with any notary or lawyer. Most people will give like a 15 or 20-minute consult. And then there are, like what I use in my practice, I've set up my own will questionnaire. And then there are many different estate planning guides. My particular will questionnaire, I do it from the perspective of information I need to know, and also allows me to do my due diligence and ask and poke into the areas of a person's life and assets to get the information that I need to know to give the right advice. And just make an appointment. Sometimes that's the motivating factor. Just do it. So consequences of not having a will. I see many people weekly. And as a notary, I have a practice in wills, estates, and advanced care planning for around health. But I also I have a notarization practice, which is really dealing with people's documents from all over the world. A very common area or theme that I see is when somebody's died. And I'll have people coming in either doing probate documents or needing copies of death certificates. Just as a side note, I do those as a courtesy and as a way of giving back to people. But I have a chance to talk to people often very early on in the session. And it's very commonly a lot of people, don't have wills. So people are sort of left in limbo. Like essentially, if nothing else, you appoint somebody who's in charge. So even if you really don't have not much money in your account, you've got somebody who can navigate all that needs to be done once you've died. But things like assets get frozen, those will happen anyway, but if you don't have somebody in charge, you don't have somebody to navigate. So a very common theme is that people feel that they've been left a mess. I can frankly say a couple of years ago, one of my brothers died rather tragically, and it's still a big mess. And that my niece is having to kind of still deal with that and grapple with that. And that was a lack, not that you could have told him anything, but that's just the lack of having a will. There may be family fighting. Again, this kind of speaks to not having somebody in charge. Death will, and certainly if it's sudden, and even if it's not sudden, grief will bring out enhanced emotions, stronger grief, stronger anger, denial, all of those sorts of aspects of grief that we expect can be very present, and not having a will can really emphasize that and emphasize the family dynamics. You may, so another consequence is what you want to happen may not happen. So if you wanted to gift to your grandkids, for example, that may not happen because you just didn't put it down, you didn't commit it. And in BC, we have particularly what's called the Wills, Estates and Succession Act. And this was updated after more than a decade in the works of updating. And we have what's called legal beneficiaries. And these are people who are defined, who are in positions to challenge your will. Doesn't mean that they will, and it really depends on the context of your life, whether or not they're in a position to challenge. And those people would be who you would expect: a spouse, a child, or a parent. So, but the law does define specifically how assets get triggered to go to your next of kin. And you know, your context of having a blended family. So that means one of you, or you have children from at least a previous relationship. That really complicates it, and that may not be your intention of how the law is stated. And not having a will. Some people think they have a will, but they actually, if it was done pre-Wills, Estates and Succession Act coming into force, which was in March 2014, your will might not be valid. And one of my very good friends came to me a few months ago and she says, "Oh, I still have a good will." Well, since she'd been separated, not quite divorced, and I said, "Just so you know, that will is invalid based on the information you've told me." And she had no idea. So the consequences of not having an up-to-date will, so we look at different, it's not just the consequences, but they're different aspects of that. So if it's made in a different jurisdiction, a consequence. So for example, you know, had a client who, they had a 20-year-old will. It still met all of their needs, but it was in Saskatchewan. They had nothing in Saskatchewan. They lived here. Primary residence was in BC, but they'd never updated to BC because everything went to each other and then over to their kids. But the reality of having a will from another jurisdiction is that you actually start, you have to take back, if a person dies and their will is from Saskatchewan, let's say, then you have to go to Saskatchewan rules to deal with the will first. And then you deal with it there, and then you have to come back to BC and deal with it. So it can cost more money. It lengthens the time that an estate gets done in, and it may be certainly more of a burden on your executor. The mind's wishes or people have changed. So, you know, you have consequences having the wrong people in the roles, right? So you may have appointed your spouse, but they're early stages of dementia, let's say, or not functioning so well. Can they actually take on these roles? You haven't, you know, the money that you're leaving isn't what you want, or in the distributions or in the shares that you want. You might want to give more to some and less to others, or charitable gifting. You may leave out people. I gave the example of grandchildren before, so it might be really what you want to do. And you may be giving to people that should be left out. And I'll talk about some reasons why in a bit. And then the consequences, what is your family legacy? You know, okay, this is very sensitive. Your family legacy can be additional work for your family members. You're leaving a mess, it's disorganized, family fighting, hurt feelings, it's not fair, what you want may not happen, and additional grief. And I kind of touched on that on the page before. And will the law decide what's happened? Yes, if you don't. Well, even an up-to-date will, the law still can decide what happens. So for example, if somebody has separated, so let's look at the Wills, Estates and Succession Act before. So there's a lot of people before that who separated with the intention of being separated permanently and forever. They just never got around to doing their divorce. But they had a will, and it still left it to that person that they were no longer with. So pre-Wills, Estates and Succession Act, everything would have been left to that person, to that really an ex-spouse. One of the aspects of the Wills, Estates and Succession Act is that it's cleaned it up. right? So if a person has made a will today, even under the Wills, Estates, and Succession Act, or even before, and then they've separated, as an example, and it's permanent, and with the intention of remaining permanent, and they've maybe only got to the point of getting a separation agreement, at the point of 2 years past, that person will automatically be removed as a spouse. So even if you are gifting to that spouse, they will drop off and it'll go to the next distribution, which often is the children. But there's always more to it than that. Everybody has a story. When I'm assessing, so when I meet with my clients, I really need to assess. I tell people, you know, your will is straightforward, probably. What you want to do is probably straightforward, but the complexities of your life and many different features will matter. And it's really this interplay of everything that I'm really going to talk about today, because these are all the gray areas that we have in our lives that a lot of people had no idea, or they didn't think to, and why would they know? And that's one of the reasons, the value of talking to somebody like me, a legal professional, is to really assess, you know, whether your existing will is up to date, or why you should have one if you don't have one. So let's talk about the existing will. Can you find it? And is it an original? Very common that people say, you know, I did one years ago, might be with my ex. I don't know, I haven't seen it for like 15 years. Or they only have a copy. They have no idea where the original is. It's so long ago. In some cases, those original wills, if they were done with a lawyer, might still be with that lawyer. But people don't even remember who they saw. So finding the will, right? You might have one, but if you can't find it, then I'm going to argue it's not up to date. Time. So when did you do it? How many years ago? I think just the passage of time, everything, you know, most people have some kind of change or evolution, natural lifestyle changes, right? So when did you do it? How many years ago is part of the assessment. The quality of the will that you did. Did you do it yourself? Did you pull a will kit off of the internet and you just did it quickly because you were going on a vacation and you had a new baby, or you just needed one done, right? Or did you do it with a professional? It's shocking. 4 out of 5 do-it-yourself wills that I see have grievous errors. People have the best intentions to get them done and done right, but they don't know what they don't know, and they don't understand the legal language. I've done a whole Zoom and Learn session on do-it-yourself wills because they're quite fascinating. And people who should know better still try to do it themselves. And the cost is actually exponentially higher with all the grievous errors to fix it than if you just paid a professional to get it done right and really get the correct up-to-date legal advice. So who was in your life when you made that will? Are they still there now? You know, have you had children since then? Have you had grandchildren since then? So who have you added into your life? I mean, you might have added a spouse. And then, you know, the nature of your relationships, right? Adding a spouse, well, it's clear if you marry somebody that they're your spouse, but what about common law, right? Common law is, in my mind, a lot of people don't realize that after 2 years of living in a marriage-like relationship, that person has all the same rights under the Wills, Estates, and Succession Act. So it doesn't matter what they try to do or avoid in income tax planning, or we file separately, does not matter when it comes to this. So divorce, separation, estrangements with people, that can be kids, parents, friends. Have you reunited with someone since then? I've had some wonderful stories of people who've given up children for adoption and have reunited with them and do want to consider them even in a token way in their wills because they've been able to have a relationship. Have some people died? Has anyone's health changed? So this is really important to consider, like anybody that you name in an existing will that you've named, is there any change in their health? Because that's a high risk factor that they may not be able to carry out the role that you've given them, like executor, but do you want to gift to them in the same way based on that? Very commonly, I'll hear that around parents, aging parents, 85, 90, all their needs are met. They have cognitive change and wouldn't make sense to give them money that they had planned on. So blended families, huge. That's a whole topic in and of itself. That's a high risk category for any will dispute. So any existing will, if it's somebody who's done it, if they've done it themselves, or they've become a blended family either through a common law relationship or a marriage, really important that they really understand many different aspects of their life, not just the relationship, but their finances really factor into a discussion. And then of course there are contracts, or there are cohabitation agreements. That's in BC what is basically what most of us would consider a prenuptial, but there can be separation or divorce agreements. There also can be, you might have parents and kids or friends buying a house together, and they may have an agreement, an ownership agreement. So those are becoming more common as well. Already talked about jurisdiction. Where did you make the will? Talking about the roles, are they still the people you want? I mentioned health, but you might just not want them there anymore. Or they've moved away, or is somebody better qualified? The passage of time, aging, maturing, all matters. What about guardians? Are there newer or better options of people? And then you look at some of the contents, has there been a changed ownership and assets? So some people will give like a family home, or a cottage, right? And so maybe some of these assets have changed, or they've been sold, or they've already been given, or there's some sale arrangement already with other people. Or you might have specific items that are in the will that you've already given away, or you've acquired more that you want to add in. A common thing is that a lot of people do not actually do is having the right to buy assets, like the first right of refusal to buy, like a family cottage by some people. So you want to assess those sorts of clauses in the will. So I've done this as I was working through every person that I talk to is always a discussion about their estate. And we talk about what are their assets. So I've listed all kinds of things there, that houses, cottage, bank accounts, jewelry, everything. Digital assets are interesting. There's so much more of that, and that's I could do a whole discussion on that in and of itself. But we really look at all the types of assets that you have. Then I look at all the debts, and debts come, there's some obvious ways like a mortgage, property tax deferral for aging people who don't want to have the burden of extra tax payments, any leases, any loans, have you borrowed money? Some things look like a gift, but they're not, like you've borrowed money from somebody else, but they kind of gave it to you, but they kind of didn't. Like there's just, the spectrum of people is colorful and unique. And the longer I'm in practice, the more I realize a lot of families will have these unique arrangements of dealing with financials or assets, particularly when they die. And then we've got, debts. Maybe you have encumbrances due to I have that twice, like due to a divorce. So is there an encumbrance on an RRSP or a pension? Did they get half of your pension when you separated? So those are things that life insurance policies, those sorts of things you may not always have the right to give. So how you own things is really overlays everything there. And I'm going to say there's a huge hot topic these days around joint ownership. And so joint ownership traditionally is the right of survivor. And so the right of survivor means the last person standing gets the bank account or the house or the car, whatever it may be. tenants in common is an ownership related to real estate. So it's kind of like if you slice a pizza pie in four, there's a quarter, a quarter, a quarter, a quarter. Do you own one of those slices? So do you have a 25% share of a home or a cottage? That's tenants in common. It's a share ownership or either generally as a percentage, or as a share, a 1/3 or 1/4 or however you slice it. And then you have in trust. So, and you have implied in trusts. You have bare trust agreements, so there's all these things that may either be just spoken about, which would be an implied trust. So an example of that would be mom adds one of her 3 kids on her bank account. And there's 300,000 in that bank account, or 30,000, it doesn't matter. But mom's intention is that that one child doesn't get all of the money. Her intention is that that person is going to get it when she dies to distribute it to the others, not to keep it for herself or himself, but to give it. These are a lot of those gifts aren't gifts, right? Do you really own it, or do you just own it in trust on, and you're going to deal with it as that person would want? These are becoming a huge growth industry. And it's really important that either a lot of this gets put in writing while you're alive, or, you just don't do certain financial arrangements to start with. Then you can own everything solely. And then you have sole with a beneficiary. So that would be, I own my life insurance solely. I own my RRSP solely, or my RIF. And you have a beneficiary, it goes direct to that beneficiary in most cases. So I look at this because I look at, how much of your assets or your net worth is going to travel through your will. How much of it's going to travel through different financial products. And these are risk factors that we're looking at that help us to understand whether or not your will is up to date and what risk factors you have in an existing will that you have or the will that you want. The key is getting correct legal advice and understanding, the biggest thing is understanding what is your objective, right? So we look at the whole to understand, I don't give financial advice, but I certainly need to understand how everything works in order to illustrate to people or let them know things that they need to consider in order for either their will to get updated, to not be disputed or not have a high risk of dispute. You can even have a low risk will that can still be disputed, but that's all about the context, right? So when I'm talking with clients, I talk about what's your overall objective? You want 50-50 to your kids, okay, or equal, but what is equal? And you really need to look at not just equal, it's not like a third, a third, a third, what's equitable? Because maybe you have 3 kids, but one of them, you spent $300,000 putting them through medical school, and you didn't advantage the others in that same way. So you really want to look at what's your objective. So the will can be one way of sort of managing that fair transition of inheritance. So we talk about what kinds of items are being gifted. Are they personal? Are they cash? How much? In what format? And again, everything on that previous page, how are the current assets held? How does your wealth transfer? I talked about this. So I'm going to go back to this because it's really, I'm just going to say it's with ICBC, kind of changing all of their rules around personal injury. There's a whole lot of lawyers who are now out of work. And you know where those lawyers are turning to? They're turning to estate litigation. So there's a whole lot of new fresh blood who are looking for where the money is. And with the complexity of our families, kids from previous relationships, blended families specifically, giving more to one than to another, advantaging the kid that never left home, right? Couldn't cut the apron string, so to speak. And so there's this whole rise in an industry where there's going to be a lot more will disputes. And so one of the things that they're looking at is not just the will, because that's just one tool where wealth transfers, but they're really looking at the true ownership of the assets. So I actually had a very lengthy conversation with our legal through our society about a situation where, you know, everybody has the best intentions, but there's the family farm. And one of the kids came in and they had an arrangement with mom and dad to look after the mom and dad as they aged, because clearly they could no longer look after the family farm, but wanted to stay there, and that was part of a family value. But kid comes on and he gets added to the title. Okay, one dies, now there's two people who own it, a parent and a kid. But the kid, who's quite an adult, has also now, with their own money, rebuilt the family home. They basically bulldozed the family home and built a whole new structure. So with all the, you know, ease to allow aging people, you know, washrooms that are accessible, with all of that in it. And they've spent their own money. But the wife of the kid doesn't have any ownership. That is incredibly complex, right? And there are many of these sorts of situations where parents are saying, you know, they become, their spouse dies, and the first thing, because somebody's told them, is we need to add one or more of my kids onto the ownership of my house. In some cases that maybe makes sense. Most cases I strongly recommend not. But it's an area that already exists where a lot of people have done that. I go back to mom adds one of three kids onto a bank account, right? Or to a house. And the intention is that that person is going to either sell the house and distribute the funds and make that a more streamlined process, or give the money away. But if they don't, then what? And so that's implied trust, right? So there's a lot of that. There's a lot of these, you know, creative financial arrangements between people that are really starting to be scrutinized in the courts. And so they're a big deal because, you know, yeah, you can do your own will, or you can, you know, have an old will, but your life has changed. It's the context of your life, your obligations, or those who are obligated to you, that you really want to talk, that you really want to understand. So clues that it's time to update your will. You've moved here from a different province or country. You have a change in your finances, whether a big plus or a minus. Certainly the passage of time. I see younger couples, they're very heavy in life insurance policies, very heavy in debt, like big mortgages, but over the passage of time, that sort of changes. And then you have, or an inheritance. Maybe they've come across, you know, a $200,000 inheritance, who knows? Or you've owned things differently. You've added a kid onto a bank account, right? Or acquired a spouse, and you've bought a home together. So how do you own things? So what, you know, all the relationships, they're dynamic. Have they changed? So that's a clue that you're not getting along with somebody, you've divorced somebody, or are planning to divorce somebody, or planning to marry somebody, or planning to be common law. Somebody's died, very clear. That triggers a lot of people to go in and get an updated will. Your own health decline. It's, you know, none of us really have the full crystal ball of what our final years, months, weeks, days will look like. None of us know if we're going to have a sudden catastrophic event like a massive stroke, or we just might not wake up one day. So, you know, we want to look at, but aging is a risk. You know, advanced age is certainly a risk. I have many people, and I'm always partly incredulous when I come across a 90-year-old who hasn't made a will. But I also am compassionate enough to know that you don't know what's happened in their life, right? They may have had some very difficult circumstances around death that have really impacted them. And so facing their own mortality is facing the fear or bringing up the loss of a loved one in the past. So I'm not judgmental, but it is very, you just need to be aware that everybody has a story, and that matters when we're talking about updating will or just getting one done. Another clue is you just want to change roles. You know it's right that you want to change an executor or beneficiary. New people added, like a birth of a grandchild. And your life has changed in fundamental ways, whatever that is, health, relationships, you name it. Another clue is you've done a do-it-yourself will or a will kit. At most, you should have them assessed, or at least you should have them assessed, sorry. And then just the fact that you're thinking of making changes is a good clue that you should be getting on with it. And you just know you need one. Lots of people know that. But it speaks about, you know, strategies of getting started. So where are you at? Are you in the black? Great. You have an up-to-date will. Are you over on the white side? No will. Time to get started. And then there's everything in between. And, you know, there's some strategies to, you know, to get started. You know, I find, so I give my will questionnaire, whether you use me or somebody else, it's absolutely a great tool to get started, to think about things, but just book a consult. Anybody, right? Just book an interview. A consult will help. You know, I find in less than 5 minutes, most people is all they need to confirm a few thoughts in their head to get started.